bank sued me for not paying interest. The judge laughed and dismissed the case when I showed him the clause I secretly added to the contract that they signed without reading. Did your client sign this document? The judge held up the contract. The bank's lawyer turned pale. Yes, Your Honor, but we didn't actually read. You didn't read your own contract? The courtroom went silent. I smiled. Let me start from the beginning. Like everyone else, I received junk mail from banks constantly. Pre-approved credit card offers. 3 or 4 every week. The terms were always predatory. 24.99% interest, $95 annual fee, late payment penalty of $39. And buried in the fine print, a clause saying the bank could change any terms at any time. One-sided contracts designed to trap people in debt. One evening, I was about to throw another offer in the trash when I stopped. I'm a graphic designer by profession. I work with documents every day. I know fonts, I know layouts, I know how to edit PDFs. What if I sent them a counteroffer? Contract law is simple in principle. An offer is made. The other party can accept, reject, or make a counteroffer. If the counteroffer is signed by both parties, it becomes binding. Banks send millions of these applications. They process them through automated systems. A clerk scans the barcode, verifies the signature exists, stamps it approved. Nobody actually reads them. I scanned the application into my computer. High resolution, 600 dpi. I identified the exact font they used. Helvetica Neue, 8-point for the terms and conditions. I matched the kerning, the line spacing, the margins. Then I rewrote the fine print. Section 3.1, interest rate changed from 24.99% APR to 0.00% APR. Section 4.2, credit limit changed from $5,000 to no preset spending limit. Section 7.4, annual fee changed from $95 to $0. And then I added my own clause. Section 9.1, cancellation penalty. If the bank cancels this card, alters these terms, or initiates collection activities in violation of this agreement, the bank agrees to pay the client $50,000. I printed it on the same paper stock. Same weight, same finish. I signed it, put it in their prepaid envelope, mailed it. I thought they would reject it. 3 weeks later, a credit card arrived in the mail. Platinum status. My name embossed on the front. A legally binding contract had been formed, on my terms. I used the card carefully for 2 years. Normal purchases, groceries, gas. When the statements arrived, they showed interest charges at 24.99%. I paid the principal balance in full. I never paid a cent of interest. I attached a note to each payment. Interest charges disputed per section 3.1. 0% APR. For 6 months, they ignored me. Then the call started. Sir, you have an outstanding balance of $847 in unpaid interest. I don't owe any interest. My contract specifies 0% APR. Sir, that's not possible. Check the contract. Read section 3.1. They thought I was crazy. After 18 months, they sent the account to collections. Then they sued me for $45,000. The court date arrived. The bank sent 2 lawyers in expensive suits. I wore a simple blazer. I carried 1 folder. Your Honor, the defendant has refused to pay legitimate charges. We request summary judgment. The judge turned to me. Your Honor, I don't dispute that I had an account. I dispute the terms. I have the original signed contract. I handed the document to the clerk. The judge put on his reading glasses. Started reading the fine print. His eyebrows rose. Counselor, is this your client's signature on this document? Yes, Your Honor, that's our standard approval stamp. And is this the defendant's signature? Yes, but we didn't actually read the modifications. The judge leaned back. Counselor, doesn't your client routinely advise customers to read the fine print? Isn't that on every statement? Well, yes, but it seems your client failed to follow its own advice. The judge set down the document. The defendant's modifications were clear and legible. The bank signed and issued a card under these terms. Claims for interest are dismissed. Then he looked at the bank's attorneys. By filing this lawsuit, the bank initiated collection activities in violation of section 9.1. The bank owes the defendant $50,000. The lead attorney's jaw dropped. Your Honor, this is absurd. This is contract law, counselor. Perhaps next time read before you sign. I walked out of that courtroom $50,000 richer. They tried to appeal. They lost. Read the fine print, or someone else will write it for you.